Okay, everyone, welcome. It is March 15th, 2023. Quite an incredible year getting off to a first quarter start. I'm Tansen Fairmont, and we're Brilliance in Commerce with the House of Freedom International Natural Law Trust Zoominar today. Randall Hillner will be joining us. We are a project of La Verite, and we have the Liberty Debt Elimination System for United States, and we have the House of Freedom International Natural Law Trust for all countries. And we have a variety of freedom enhancing and wealth building programs and special offers and information. So if you're already a subscriber to the newsletter, thank you. And if you aren't, you'll have the invitation to enter a subscription. We're members of the Worldwide Charter for Fair International Commerce. So if you haven't already, take a look at that on the website. You may be pleased. Today, March 15th, 2023, we're going to start doing our trust webinars quarterly. So the next one will be June 14th, 2023. But of course, there will always be availability for consultation and small meetings in the meantime. If you want to play back any of the past programs, go to brilliance-videos.com. That's the address of our YouTube channel, brilliance-videos.com. house-of-freedom-trust.com for those who don't already have an affiliate link, and sign up to the newsletter. Our phone number for those calling in by phone, 360-200-7521 in the United States. All right, and my name is Tansen Fairmont. I'm the founder of Brilliance in Commerce, a consultant on bank instruments programs, and speaker on various past radio shows and seminars. Randall Hillner is the head of our trust department, the founder of House of Freedom Trust, founder of White Light Unlimited, trustee of One People's Public Trust, and the creator of this most excellent world-class House of Freedom Trust. Dominique Hackett works with us and assists and is in the background and conducts study groups and provides consultation and trust services. So she's created numerous trust study group classes based on books recommended for study. These replays are available on the BIC website, client login under My Account, for individuals who have purchased one of our trusts. And for new trust creators, Dominique also offers to act as a nominee grantor for those located in the United States, subject to a suggested donation. If you require Dominique's assistance, please work with Randall, who will pass an email on for Dominique to coordinate a Zoom meeting. Additionally, Dominique is in the process of developing a separate website, eduprivatetrust.com, which shares advanced trustee administration research privately, member to member. Laurel White is also a protege and a part of the team who is in working with Randall and provides similar parallel trustee services and assistance and support. So you may have encountered Laurel at some time. She joined our program once or twice and was kind enough to speak with us. Today's topic, we have fiduciary responsibilities, conflict of interest, trust friends, and royalty. Loyalty is a most important part of it that has been gone over before, but Randall wanted to review and enhance and elaborate on previous topics regarding these themes, the fiduciary responsibilities being so important. And a lot of people have indicated to Randall through their questions that they didn't really get some things he explained years before. So today we're going to review some of those years before kinds of topics. And Randall, go ahead. We'd like to hear from you.
Okay, let me get my headphones here. I'm speaking to you through my AirPods. Okay, hopefully that's what's happening. And welcome to another Zoom of Brilliance in Commerce and House of Freedom Trust. And again, we have another month gone by, and we're going to just dig right into it again, because the fiduciary responsibility and conflict of interest can easily pop up, because, as you know, we give you choices to do whether you want to be the grantor and the beneficiary and not be a trustee, or whether you want to be a trustee and not a beneficiary. And so it's really crucial that, depending on what you know about the responsibilities of the trustee are, that you remember to go into these positions with knowing that there's a fairly good amount to learn, so that you can run this trust on a very good level of competency. And that's what we're here to do, to fill you in and make sure that you can work it and do it correctly. So this is just a summary that we've done. We have a number of books or reference books that we use. One is a book from Europe and the European slant. And the other one is my trust law from the US, and all of the latest updated versions of the law. So we're going to relate to a book that has been entertaining for me, and we're going to talk about fiduciary responsibility. This is from Penner, 11th edition, Law of Trust. Okay, next slide, please. So, okay, so we have a director or a trustee. So we've got to remember that when we're dealing with trust, we're talking about trusteeship. You step into the role as being a fiduciary and a trustee for this particular trust aspect, and that inherently brings certain responsibilities and duties that you are called upon to provide. And when you get the trust document, I emphasize over and over and over again that the people that you as either grantor and beneficiary, or you as trustee, you must read the document well enough to understand it. And I've read it over and over and over again for 30 years, and it's still, whenever I go back in, I went, oh yes, that's how to do this one, and that's a better explanation of this over here. So the bottom line is that the trustee has a fiduciary responsibility to the trust and to the beneficiaries, so that he'll do his best to make the assets that are in the trust continue to be enhanced, or be in a productive mode, or maintained for a certain level to be given for specific purposes. And what we get to see is that some trusts are made up for, they have an asset, and that asset is to be put in the trust for the beneficiaries. And it's supposed to dial out so much per year until the whole asset is gone. Now, if that's the situation with you, then that's what the trustee must do. He must make sure that he continues to pay the beneficiaries, give them the due that they deserve to have, and make sure that the trust is kept intact. And the best way to keep it intact is obviously to have a paper trail. I mean, on certain aspects of our life, we don't want to leave a paper trail, but in other aspects, on the competency on the professional level, it's good to have a really good paper trail, especially with the use of trust. And because there are so many mechanisms involved, and ins and outs and missteps that can happen, that we want to make sure that if you're in the role as a trustee, that you know where your loyalty lies, and that you're in good faith trying to produce and the best results that you have for this trust. And avoidance of conflict of duty and self-interest. So one of the things that we'll talk about coming up, I believe. This is what your duties are and what your self-interest is. So we could have the next slide. Okay, requirement to avoid a conflict of duty, a self-interest. This means the trustee is precluded from obtaining for himself, either secretly or without informed approval, any property within the trust business. In other words, if the trustee knows that something's going to go down, that there's some business acquisition about to happen through the trust, and he is privy to hear that knowledge. And if he goes out on his own and tries to barter a better deal, then that's a breach of contract, and that's his burden to carry, and he should be immediately either replace the any capital that would have been put into the deal, and he must pay back the trust out of his own pocket or out of the deal that he did on his own. So it's really, really important to not to be a trustee and to not take anything that doesn't protect the assets of the trust and give to the benefit of the beneficiaries. Really critical point, and that's what keeps the trust whole and keeps everybody in shape. Okay, slide. Okay, now if you choose to be a trustee, put some thought into it and be a trustee because you're a member of this family and you want to make sure that they're taken care of and they're protected and that they have benefits for a long time into their life process. And so we do that by making sure that we stay involved with the trust. And if we need to resign, that we let the other trustee know, the other co-trustee, or we let the beneficiaries know, and we go out and we find a replacement of equitable value. In other words, we want to go and find a trustee that can replace the competence that the former trustee has. Because if he's been a trustee for a period of time, he's learned a lot about what the trust process involves. And it doesn't mean that he can't go out and peddle his wares somewhere else. But if he does take a process out of one trust and tries to do it for his own personal gain, then he's definitely in a breach of trust and he should be let go of immediately and replaced by somebody with competence and more loyalty to the trust. Okay, next slide. Now, this elderly couple has been dancing around the floor for probably a number of generations and been in a wealthy family. And I'm sure that the fiduciary responsibility of the wealthy have been taken care of quite eloquently by people of stature and people that know what the law of trust is. And that's what we want to produce here for you, is the ability to take your assets and make sure they're maintained or multiplied and enhanced so that you can live a lifestyle that goes according to who you are and who you want to be. You don't have to live this lifestyle by any means. Certainly I don't live it in Hawaii, but then again, I drink a lot of coconut juice. So here we have a situation where the relationship exists and the whole essence of being a competent, responsible fiduciary for the trust, being a trustee, is to be competent in what you do, read the trust manual, read the trust document, make sure you have an adequate accounting program. I think our associate Dominique is going to is working on creating an accounting program just for trust so that it becomes easy for you. And all of that's in the process, but it's a simple bookkeeping process. If you have your check at the local bank, then you can get the statements that keep in accounting and have the accounting ability. There's absolutely no reason why you can't make sure the accounting for the trust isn't a very ongoing process. Very simple. Okay, next slide, please. Okay, so Act time of the trustees will in contract for the trust subsists. In other words, if you're in the process as a trustee this week, this talk is all about being a trustee, competent trustee. If you have a contract in the trust process that you're in right now, you're a trustee for the family or for an element of functionality or business, and you're the trustee, then it's important that if you involve with a contract for the trust, that you cannot take it with you if you decide to leave as a trustee. In other words, you'll be in breach of contract if, and loyalty and fidelity, if you are involved with a contract and you take it away from one trust and take it to another one. That is definitely a breach of trust. And that's a breach of loyalty and fidelity to the former clients you have. That doesn't mean you can't take your wisdom with you and all your learning process and your ability to transmit the assets and the productivity of the trust into the beneficial interest, and that's fine. But to step aside and create a process of disloyalty or non-fidelity is not the way to be a trustee that's always asked to step in and take control of the trust. I mean, when you have the competency of being a really good trustee, word will get around and you'll have work to do if you want to pursue that avenue. I have an apprentice program. Laurel, our new associate, Laurel White, is accelerating so fast forward. And it's a good learning tool to have for your life, especially if you're starting as a trustee with a younger element of trusteeship. Okay, next slide, please. Okay, so here again, we're talking about a level of knowledge that you are going to learn by being a trustee. And so if you work with me at all, you notice that I have a great bibliography, and depending on how much you want to put forth into an effort to be a trustee and to be a competent trustee, then you can do that. But if you're going to be a trustee and you're learning the process, you need to make sure that if you leave the trusteeship of this particular trust, that you don't take anything that could be a breach of trust with you. In other words, anything that belongs to ABC Trust should stay in ABC Trust. And if you want to go to EFG, then go there with the knowledge that you have, but that you're not going to infringe on any contracts from your prior commitment. I don't want you to be in breach of trust. It's not a pleasant experience. Okay. Next slide, please. Okay, so you can get away with certain things, but what we want to do is it depends on whether he left. The resignation happens because he's gained enough knowledge and competence that he wants to move on to a different opportunity. As long as he doesn't make sure that he doesn't take the business opportunity with him when it's already established in the prior trust. I think we talked about that you just want to leave it there and take the knowledge that you have and then take it into this new position with a company that, that deserves your trusteeship competence. So you don't take any projects with you from the prior trust, but you can take the knowledge that you've gained and apply it to new opportunities. Okay, slide. So again, the underlying basis of liability is if you you take a contract that you've had with a prior trust and you go out and you try to create that opportunity again in another level of business acumen, then you're really stealing from the prior trust, and you have to be really competent and really aware that if you're going to take anything, you're taking the knowledge base that you've acquired through working with this particular trust aspect in this trust contract and take it to the new trust endeavor, but take it without dragging any contracts from old or any baggage that might hold you back or put you in jeopardy of being a breach of contract to prior beneficiaries or assets of the trust. Okay, another slide, please. Okay, and what we see that common law today, because what happens is, let's say that the trustee, if he's mistaken, if he's made an honest mistake, then in his investment policy for the trust, then that's not a breach of contract. That's not a lack of fiduciary responsibility. It's an honest mistake making on an investment process. But if he's done it intentionally, then that definitely has to be looked at. And if it has done it intentionally, then it's required by law to repay that. What happens also is that if he goes, if there's a slight, his word against somebody else's word, or he said, she said, then you have to be careful, because he can go to a general meeting of the other trustees and say, look, it was a mistake. It wasn't an obvious breach of conflict for me. And so I, don't want it to happen. So you'll have that, and the trustees have to just be honest with the situation and say, okay, we've seen you've done this and this, and mostly your work for the loyalty of this trust program and the assets involved with the trust, and we want you to stay on, or we've decided they would like you to resign. We're going to bring somebody else in. So just remember that this is an endeavor to keep all of the people involved with the trust on an upscale level, and putting the asset base that's in the trust ahead of any personal potential gains you might have. And that the whole idea being a trustee is to having the assets, being able to take those assets, place them in different investment bases, and then be able to serve the trust with loyalty and dignity. And that's about the top that I can say for being in tune with being a good trustee. Is there another slide, or do we have questions? Aha. Inherent jurisdiction to authorize remuneration for the trustee. Okay. Okay, so one of the things we have a clause in our contract is that if the trustee is put on in a place where he needs to use his skill and use his energy to help create more of a jump in the ability for the trust to make money. In other words, he has some opportunities that he wants the trust to look at, and he should be paid for that, the amount of work on a commensurate level. He should be able to be paid for the work that he does that enhances the assets of the trust for the benefit of beneficiary. And maybe in the past, the court didn't authorize it. In the early days, if you were going to be a trustee of a trust for the Crusades, there wasn't any compensation due. You just held the land in the name of a trust for the Crusaders going off to war. If they came back, you held the land for them and took care of it. They didn't come back, then they had beneficiaries they wanted it to be passed on to. And that's what it is. And so you need to make sure that the trustee is loyal to the trust, that he's thinking for the endeavor of the trust to be first and foremost, for the beneficiaries, and that he's compensated on a justifiable and equitable compensation for the work that he does. Like any contract in the world, the journeyman or the layman is due his wage. So trustees are in their due. Any office in the trust endeavor earns his due. Beneficiaries should have their process taken care of, and the grantor, depending on whether he's a beneficiary or not, can be compensated as well. So that kind of sums up our loyalty and breach of trust for the trustees. I think just it's reading the two books again that I had added some spice to it, but basically it's a worthy endeavor to be a trustee and just step up and take care of business at hand for the benefit of somebody else, and to be compensated for it. If it's outlined in the trust document, then nothing wrong with that. Okay, do we have any questions, Tanzan?
You have several more
Another
slides,
slide.
remember?
Oh, well, it's just it's an enhancement of any unauthorized profits. In other words, if you get a commission because you put a deal together and it didn't go to the trust, then it's important that you pay the trust back that commission. That's a breach of contract. That would be whether you were a trustee or whether you were a manager or whether you were just a contractor doing the job in the middle of a house, or you were an investment broker and you got a commission but you didn't pay the trust, and that's definitely a breach of trust. Or any secret profits that you get from doing a deal at the side. So the whole idea is to, if you're going to be a trustee, learn how to be a trustee and don't breach your contract, don't breach the trust, and take care of the assets for the benefit of beneficiaries. Self-dealing is, in other words, you're putting yourself before the property. A fair ruling is show that you've done the work if you're going to be expected to be paid as a trustee. There's nothing wrong with being paid, but just make sure that you do the work that you said you do. And that's why I mentioned that a paper trail is really important. Okay, Tanzan? Proprietary and personal nature. So remember that as a trustee, you're liable to account for the recognition that the property is in trust hands. So in other words, if you're a trustee and you go and become active in the process of that trust, that you must make sure that all the bank accounts are shifted to the name of the trust, that any property is shifted. If it's being shifted, assigned for the nature of the trust, then you have to do it in the trust document. You also have to go to the county recorder and re-record the property name to the name of the trust. And remember, the trustee, it's not your property. It's the property of the trust and the beneficiaries. The trustee has legal and lawful title to property, but it's for the benefit of somebody else. Okay, hopefully that raised a few questions. Ultimately, it's a wise and knowledgeable trustee who knows that friendships and loyalty, right action, keep the trust safe and profitable for himself and specifically for the beneficiaries. Trusteeship is an important role. Okay. Questions?
Okay, everyone, if you're calling in by phone, you can press *9 if you want to speak. If you're on a visual device with Zoom, you can type it into chat or click on the raise hand icon. So right now, Randall, we have a few in the chat already. The first one is from Deborah. She says, I've never run a trust before, but have run businesses. You are talking about the skill of a trustee. Could I be putting the trust in jeopardy by being green?
Greedy? No. If you run a business, you're going to be able to run a trust. It's the same thing. You're running a business, but it's underneath the equity laws of trust law, equitable chancery court, and underneath the law of trust. And if you can run a business, then you can run a trust as a trustee. And greedy is making sure when you run your own business, being greedy means that you're giving more into your own pocket. When you're a trustee, being greedy is that you're putting more money into the beneficiary's hands. And that's your job as trustee. So in a business, you're only accountable to yourself, whereas in a trust, you're accountable to the beneficiaries.
Yes, thank you. Randall, may I add? Look, everybody, it's really simple. Randall is fantastic at going over the laws and the protocols and the procedures, which is important. But in real practice, in real life, it's really as easy as running a business or managing your personal affairs. You're just doing it in a different name and hopefully building it up for the benefit of the beneficiaries, but distributions can be made at any time, tomorrow, next year, 10 years from now, 20 years from now, depending on everyone's agreement in the trust. And the trust is discretionary. So that means the trustee has discretion to decide about distributions and timing. And yeah, just don't be intimidated. It's not so difficult as it may look.
If you can run a business, you can run a trust.
You're just doing it in the trust name.
Yes.
So PL says, how are disputes settled if you work with an unknown professional trustee? How do you know you can trust that person? What are they commonly paid? If a trustee steals, what protection would you have? So there's quite a few questions in there. Let's just start with, how are disputes settled?
Disputes are settled in-house. Typically, that's why I suggest co-trustees. And the trustees and the beneficiaries would get together and they would decide, what's a fair stance on this process. And they would do it in-house. If it's not done in-house and it gets too cranky in-house, then you would have to go to a equity court, a court where you're talking about dollars and cents. It's not a criminal nature. So if it has to go to court, it would be a common law court dealing with equitable process. So it can be done. I have law books that are filled with court cases on how the court decided and whether it was overturned later or has been remanded back to the court, etc. So there's a lot of information, and it doesn't take a great deal of acumen necessarily. You don't have to have an MFA or MBA. You just have to have your common sense about you and know that you're doing the job for the benefit of the beneficiaries. Typically, when you have families that are maybe the trustee and the settler and the children of the beneficiaries, it's all done within house. If it's done within a business, then it would be within the business partners. And if it's done, where there's lawyers involved, then the lawyers would have to get involved, but it doesn't negate the process of an equitable trust.
And it's important to recognize that the jurisdiction is limited. Wherever any dispute might go to a court, is only about the transaction in question and not about the permission of the trust to exist. right,
Right.
Randall?
Correct. Only about the event, the immediate event at hand.
So he's also saying if you work with an unknown professional trustee, how do you know you can trust that person?
Well, I wouldn't unless you sat in front of him and had a reading and looked in his eyes and shook his hand and say, okay, I either trust this gentleman or not. That's all you can do. I mean, that's all you can do with anybody, even your best friend.
That's
But
right.
typically, because of the law and the way it's handled, somebody never in my 35, 40 years has a trustee ever run off with anybody's money. Never had it. So it's not a chancy thing. It's you're looking at friends or people that you would trust to begin with, and you ask them to be a trustee.
I have to say, Randall, that you've seen it the same as I have. There are all these other trust writing organizations out there, and most of them are very militant, right? I mean, they kind of talk, like bulletproof and court cases and laws, and we protect you, and almost like they're in a criminal world or something. And you somehow your whole vibration, your whole manner of constructing the trust, the clauses that you've collected, treat the client as if he or she is a virtuous, well-intended, harmonious person and peaceful, and maximize the freedom for the trustees, right? And the protection of the assets. And
Absolutely.
your clients stay out of trouble. That's one thing I've just always admired about you and how you work. Is there's something about the way you construct the trust and guide your clients is we just don't know of any disputes, even though you have to talk about it. You have to go over the laws and the regulations and all that. But we, right, we just don't have incidents of our clients getting in trouble. Knock
But
on
I
wood.
do have clients that call me and they ask for advice on how to do something so it doesn't jeopardize their client relationship. And so that's what's unique about, I think it's your attractiveness as well, Tanzan, is what we do here together is we're not just training people to be trustees, we're upgrading their level of consciousness around not just the trusteeship, but about commitment to relationship and commitment to the beneficiaries and doing the job correctly.
PL is also saying, what are they commonly paid?
It just depends. I think what's the common rate for a good, a well-known, competent person is worth $50 to $100 an hour. The lawyer gets $200 to $300 an hour, depending on your wealth. It just depends on where you fit in. The thing of it is if you have somebody come and do a lot of work, then that's going to be chargeable fees. Whereas if you come in and you hire a trustee, but you do a lot of the work as manager, then it's going to be on you and you're going to do the work, and the trustee's going to do minimal amount of work except sign off on the papers that you produce. So it doesn't have to be an expensive deal, but anywhere from $50 to $60 an hour to $100 an hour is not unheard of in today's economy. I mean, I think the minimum payment now at minimum wage is $30, $40 an hour. So I'm outdated. I just view things accordingly. And I think it's up to everybody to work out their own schedule, how much they value their commitment to, if they're learning how to be the trustee and they read a number of books, then pay for the books and pay for the educational process of your trustee, because it'll always be beneficial to you down the road in the long run.
And his last question is, if a trustee steals, what protection would you have? And PL, if I just may comment, we are one of the only trust writing organizations in the world who not only allow, but encourage the client to be his or her own trustee. Unless you're too young or too old, you have more control, more safety, more protection, and more convenience if you are the trustee, right, Randall?
That's correct.
But if you appoint someone else as trustee, then you may also want to have a protector. Yeah.
Protector, the clauses within the document, yes. But even people that appoint protectors, I've never had one come back and say, I had to use my protector, what do I do? And even we cater to a different clientele. We don't try to make you have to have these, but we say, look, if you're going to protect your assets in the long term, then do it now. But sooner is better than later. You want your trust to have some seasonability to it, and make sure that you're running it correctly, and then it will stand for hundreds of years, generations.
Yeah. All right. And I can't quite read the first name, but the question is, good evening. Once transferring property in trust, can it be used as collateral?
You wouldn't be able to use it personally, but the trust could use it. Depends on what the use is. Now, I've had people that they put their house in trust and then they want to take out a loan, they paid down the equity or paid down the loan, they have a lot of equity and they want to restructure their process. So what I have them do is I have them take the house, the particular asset out of trust for a short period of time. They go to the bank, they restructure their loan, then they take the house and put it back into the trust. Now we'll have a mortgage on it this time, but it doesn't matter to the trust because the trust is all the trust is doing is separating the asset from your pocketbook. So you don't have it on your desk. And if something happens, if there's a liability, then that asset is not going to be taken advantage of because it's in trust.
Okay, thank you. Very good. And Beetle is asking, if a trustee lives far away and needs to file a property with the county recorder, can it be recorded in any county?
You have to go where the property is. You'll have to go to the county recorder where the property is, more than likely.
Yep. PL is asking, where do you find common law rules?
You go into the early law books and you'll find that most law was based on common sense. Common law came from England. It was the basis of law that based on two premises: honor your word and don't hurt anybody. And that's all a contract is: honoring your word to contract, you and trustees and a third party, and don't hurt anybody. It's certainly you're all right to defend yourself, but the idea is not to go out and be the cause of action, whether it's contract or criminal.
Very true. And you can also study the UCC, the Uniform Commercial Code, Beetle, because that's kind of a codification of commerce and trade in common law agreed upon by countries worldwide and went global. And so then we have the question, he's saying, thank you. I have been reviewing the trust as I want to do this as soon as possible. I have heard someone say you need 3 trusts, one for the public, one that bridges both public and private, and one private. Is that true or false, and why?
I don't know that you need to have a trust for each endeavor. My trust minutes are private. They can't be read by anybody unless there's a subpoena in the air. And but on the other hand, I'm not worried about letting somebody, the banker or somebody, see the trust document itself. As long as the minutes are kept private, then it's not it's not something that you have to keep in a safe deposit box all the time. You're going to be using this all the time. You're going to want to have a book on your desk every day, day timer, noting what actions or reactions that or decisions that the trust has made, and keep it going. It's a every day. It's a live process. It's always happening. So you want to keep it enlivened, and you want to keep it up to date. And if you're doing a lot of business around the trust, just keep a lot of notes.
So in other words, Randall, I think you're saying that all natural law trusts are in the private, but they can interface with the public, right?
Sure, I interface with the public all the time. I mean, outside of a contract, a signed contract with a client, everybody in my sphere is like my neighbor, my family, and I'm endeavoring to be as inclusive as possible and to having everybody know what I know. I'll give you all the knowledge I have. Just take it and run with it. If you have questions, and fine. Otherwise, public, private, or social, it's all the same. So I can't quite get why you would need a private, a public, and a case closed trust, because I've used House of Freedom has been around, White Light Limited since 90, early mid 80s, and trust documents that I've got 50-year-old trust documents. Well seasoned, well used, never abused.
And the Board of Trustees voted to continue them, yes?
That's correct. Some have left, some have died.
Yeah. And someone's living forever.
Right.
So Mark, as to how many trusts, the old idea is never put all your eggs in one basket. It's just classic asset protection rule. So it depends on how many assets you have and how large they are. It's kind of more of an art than a science, but you want multiple trusts if you have multiple assets. It's kind of a simple rule of thumb.
If you're doing real estate, you might want to have, and I don't know what real estate is nowadays. I hear it's $500,000 just to buy a bungalow. But, if you had 5 to 10 pieces of property, you might want to divide that up into different trusts, 3 or 4 trusts, so that if something happens to one piece of property, it doesn't affect all 15 or 20 pieces of property. That's the whole idea of this natural law trust, is to separate out your assets so that they're not all in one basket, as Tanzan just intimated. So that's the whole idea. And don't put anything that's a liability, never put into a trust with all your assets, any asset.
Marianne's asking, couldn't you also use a mediator if necessary?
Yeah, but I've never had that issue.
And we don't know of anyone who has among the clients, right?
I haven't.
But yes, Marianne, if need be, you could use a mediator. So DC is saying, Randall, I need a little help to put assets into the trust. Do you offer help in the process?
Sure. If you're a client, you just need to, you should have my email address, and you email me a couple of questions. If I can answer them, I'll get back to you and we'll break it down. So yes, I'm always available to help.
Yeah, transferring assets into the trust is one of the most common things that you've been doing, Randall, for
Right. There's a schedule. There's Schedule A is for personal property. It's for gold, silver, stocks, bonds, personal artwork, etc. Anything of value. And Schedule B is for real estate. So you would have maybe a page for each particular house that you have, if you're a realtor, a broker. So it's just all paper trail, like anything. Like I said in the beginning, we want to keep this tight so that it's all documented.
All right. So Catherine is asking, if the main asset in a trust is a not-for-profit business, can an employee of that business also serve as a trustee?
Yeah, as long as he's not a beneficiary.
Mm-hmm.
So yes, if he's not a beneficiary and he's one of, if he's not the sole trustee, then yes, he could do that. It needs an independent, non-related second co-trustee.
Okay, thank you. And Mark is asking, is it allowable to, if say my sister or friend sets up a trust and I set up a trust and he or she makes me their trustee and they are the beneficiary and vice versa, is there an issue of conflict of interest?
Well, as long as there is a second co-trustee that's non-related to opposites. So in other words, an ABC trust has a XYZ factor and the other trust has a MYZ factor, then you could do that, but you need to have a non-related third party in there somewhere so that you're not just switching, because otherwise you're not creating separation in your assets.
Right,
It's too close.
right. And his related question is, can a husband and wife do the same?
Well, you can, but it's not the best way to do it. Because what'll happen is somebody will look at that and say, well, if you have the power, if there's just two of you and you have the power to manipulate the assets, then you don't have an irrevocable trust. You have a revocable trust, and so it won't stand up in court.
Right. So his final part of his question is, a husband has his, wife has hers separately, and they make each other the trustee of each other's?
You need and I'm saying that there needs to be a third party, non-related trustee,
Right,
co-trustee. And it can be the same person on both trusts, but as long as he's not related to either one and he's not related to the beneficiaries, then you're fine.
got it. I hope that's clear, Mark. Okay, Bo is asking, it's my understanding that you can hold 2 out of 3 hats. If a husband and wife form a trust with a nominee grantor and they have an adverse second trustee, if the husband is named the primary trustee, is it your opinion the husband can safely be a beneficiary along with his wife being a beneficiary, or is it better the husband is not a beneficiary?
You can't be a trustee and a beneficiary. So you have to just remember that you can be the trustee and you can have a non-related second co-trustee, but you can't be a trustee and a beneficiary. That's the only situation where you can't have those two hats on.
Right. We already discussed earlier how the trustee is compensated through other channels, not through being a beneficiary.
Correct.
Yeah. Danny's saying, can beneficiaries be added or removed?
Yes, anytime.
All right. And Deborah's saying, I have been told that if a pure private trust holds any public deed, then it is pierced as it can't be in the public.
That doesn't make sense to me. And we just talked about that, how the trust that we have can operate in public or private experience. It's not an issue.
Yeah, Deborah, that's never happened to any of us that we know of over 5 decades. So I think this whole public-private kind of philosophy that you may be studying could be confusing you. Yeah, those are not real world issues. And Bo is saying, do you have a template for an asset holding trust that does not have a bank account, which would be different than your management trust that manages your business?
There's no difference between the documents. One is going to maybe have a minute that says one thing, and one is going to have a minute that says we do another, but the basic outline is the same. Doesn't matter which way you go. The trust is fluid. It's a vibrant moving document, and even though it's static in a lot of instances on what the powers are, it's a very fluid process, and the whole idea is to make this work for your life. So if you're going to be bringing in your family, if this is a family trust process, then you want to make this very fluid, and all you're doing is separating your assets out of your liabilities. You take your assets and you put them in the trust, and you leave your cars and your kids on the side of the road. So if they get run over, then they're not affecting your asset base. So just remember that as a basis, is you're protecting your assets, you separate them out. You have to have some non-related trustee in there, so that they're not influenced by the meaning of, or the settler or the beneficiaries. And then you just make it work. It's very simple. It doesn't have to be complex. Even though it's considered a complex irrevocable trust, it is not that easy to run.
Well, it's known, Randall, that one of the signs of genius is to take something complicated and make it simple, and that you have done.
I hope so.
So, Bo, there's not a need for Randall to have different templates, as he was saying. There's a single template, but it's infinitely flexible. Imagine it to be kind of like a very high quality, finely tuned Rolls Royce or Lamborghini. Okay. It can be the same vehicle for 1,000 different people, but each of those 1,000 different people will take it 1,000 different directions to go different places. So it's kind of like that with the natural law trust. You can fulfill any noble purpose with it.
Or multiple purposes.
Multiple purposes as well. Yeah. But it's one single template that is adaptable. You can turn it from a family holding trust into a scientific institute or a foundation. It can be styled as a private membership association. It can be flexible to be adapted to just about any good purpose.
Correct.
QO, I guess is the name I was, forgive me if I don't know how to pronounce your name. This saying thank you. So if there is no mortgage, it might be best to leverage property than put it in trust.
I'm sorry, say that again.
He's saying it might be better to leverage property than to put it in trust. In other words, take out, max out the equity in terms of mortgage, so that it's no one can steal the equity, because there isn't any or very little.
Yeah, but what are you going to do with all that cash? Then it's in another pocket, and how are you going to take care of all that equity?
Right. Then you have to pay the loan back with interest, and
right. You're going to lose in the end. So you have a trust, and the trust protects the equity that you have, whether it's in an asset base or a money market or wherever it's in. Might be you just buy cars, restored cars, and you have those, and they double every 10 years in equity. So that's all you need. You just need a place that, rather than you own them, the trust owns them, and then they're distributed as you see fit. And there's no probate. It never ends.
Beetle is saying,
client that is got an issue with siblings that are fighting, and the parents passed away, and nothing was written down, it was all oral, and it's just a mess. And if they had done it right away, if they had started right away to separate the assets, put them in trust, or at least certainly have directions of how you want your estate to go, that's really important. It's not just having a trust, it's having your estate in order so that it doesn't get tangled up in all the mess of either family or social or government stuff.
yeah, it's a very beautiful state-of-the-art estate planning device. So Beetle is saying, maybe I need to reframe my last question. If you need to record a property with the county recorder and your trustee doesn't live nearby, what do you do? Doesn't the trustee have to be there in person to do the recording?
You'd have to go to the recorder, and what can happen is that the trustee in another city can go to a notary and sign the documents that he has, and then it would be faxed over or scanned over to the county recorder, and it could be recorded that way. You just have to check with the county.
Yeah, that we don't think
Yeah.
that the trustee has to physically show up in person.
Yeah, I mean, there's bank accounts now where if I have, like, the trustees are in one city and the bank accounts in another, then I just have the client go down, and the trustee in the other city just scans or faxes the particular document right to the banker and the client, and it's all taken care of.
There's
So
your answer,
people now
Beetle.
are getting savvy to, doing things online. You don't just have to go there in person. The ability to scan and take, have the authenticity of finger matching or face matching it's all in order now, so that you don't have to physically show up. You just have to prove that you are who you are.
Yep. Perfect. Thank you. Yeah. I hope that explains it, Beetle. Abra, nice to hear from you today. Abra saying, I was watching a webinar that was about the QFS, cryptocurrencies, and so on. The host said that all trusts will be invalid once the QFS rolls out because the wording in trusts will not have the new language of the quantum financial system. I figured that one would just do minutes to make any necessary changes, but maybe the indenture would not have the correct wording for the quantum system. What do you say?
I say that you could take this trust anywhere you go in the universe, and it's just a contract. It's simple. You can call it a trust contract, or you can call it a corporate contract or a 508 contract. It's just a contract between three people, and you can take it anywhere, and it doesn't, the QFS coming in won't necessarily negate it, because you're just in a simple contract. I, as settler, want ABC to be the trustee for XYZ, and that's all there is. It's very simple on that level. The
Right.
complexity comes in how to make it work, and that's what I'm here for.
So Abra, what they may have been referring to were statutory trusts, because the QFS may make a lot of statutes obsolete. So yeah, we could see how maybe statutory entities might get obsolete and would require redesign. But the difference with the natural law trust is that it's not written under statutes that change every year. And that's why, is because it can go on, like Randall said, anywhere and anytime, without being made obsolete by anything in the environment. Even the language for the financial system doesn't apply to private contracts. The only applicability would be when you put assets into the trust, the maybe different kinds of assets that are conveyed differently because of the new system, but it doesn't change the basic structure of the trust.
Very well said.
DC says, thanks. I will be purchasing the trust tomorrow. I will look forward to working and learning a lot from you. Daryl. Okay, thank you, Daryl. That's nice and welcome. Peter is asking, since the trust can borrow private loan and can own a business statutorily registered, such as automobile leasing, if the trust pays a service fee to its owned business, invests the borrowed funds, and produces profit to repay the loan, I have a concern that state and federal agencies like the SEC could purport the trust to be offering investments without a license, as they are always known to purport. Where is the boundary to keep statutory regulators coming through the owned statutory business to try and penetrate the trust?
Show me your subpoena. Show me where the judge says that we're in error here. That's what you have to do. You individually will have to stand up and say, show me your stinking badge. So that's what I would say, is that nobody can come in unless there's a valid process happening. And so that's a distant, I mean, like I said, we've 40 years and never has anybody been really challenged on what the running of our natural law trusts are all about.
I'm analyzing your question, Peter, and I can't find where, like Randall said, where would be in the liability? I don't see any problem. And it's certainly not offering investments, and it's certainly not doing something that violates statutes, such as offering investments without a license. In a business, the title of ownership of the business goes into the trust, but the business itself can still have a license to operate whatever business it's in. That doesn't affect the trust.
No, and if you're doing a business, the trust is doing a business where it requires a license, you're going to need to get one. The trust will get a license. That's all.
Yeah, like let's
Yeah.
say you're a real estate broker, you need to have a real estate license.
Yeah, sure. You
Put
need
that
to have,
business in the trust.
if you're a contractor, I ran my contracting business through the trust, and I just had, the trust had a bank account, and the client paid my contracting company the money it needed for it's a weekly process.
Yeah. Okay, so Aubrey says, in regards to being a trustee and beneficiary, is that true if you have a separate grantor and other beneficiaries?
No, you have to run the business of the trust, has to be run accordingly as it was set up to do. And as trustee, your job is to make sure that the beneficiaries are given their due. So if you can't operate within those parameters, then, think about not being able or having another trustee come aboard. But basically, if you're asked to be a trustee or you're looking for trustees, have somebody of like mind and like your way of life, so that you can just step in and say, hey, I'm doing this. I'm looking for a trustee that's competent and is honest and high integrity, and go from there.
Deborah's asking, can you donate from your 401k into your trust as a tax deductible donation, relieving you of the income tax liability if you are below 65 years of age?
It would depend on who's holding your funds at the moment, whether they can give to that particular your entity or not. And it depends on the transfer and whether taking money out of that fund would be create a taxable event. It may or may not. Don't take it out first. Just check and see whether it's a taxable event.
In other words, it's not for us to comment on because it's not a natural law trust issue. It's the decision is made by the payor of
Right.
the retirement pension. So yeah, that reminds me, everyone should be reminded that when you speak to corporations, banks, government agencies, any systemite about this trust, don't use the word natural law trust. Don't use words like sovereign trust. Don't use words like common law trust or tier trust. Just call it a private contract trust, right, Randall?
Correct. Private irrevocable trust.
Irrevocable. Yeah, those are the words that you want to use with systemites. All right. And Catherine's saying, as we transition to a legal system designed for the golden age, what, if any, changes in the applicable law do you see affecting your trust and any possible taxes on them?
I don't see any because it just depends on whether you want to be in the system. The trust itself as a contract is outside of the jurisdiction of the tax agency. And if you're in the tax agency, then you're in the tax agency, and nothing will affect the way the trust works, or it doesn't work, depending on how well you keep minutes and how well you adjust the business of the trust. But through age and time, everything changes, and the dynamics of the trust will change, and your trustees will change, the beneficiaries will change. I mean, look at the Rockefellers and the Kennedys. They've been operating for 150 years. So it just goes on and on and on. And the adaptability and flexibility is within the ability, it's the nature of the trustees and how they can make things happen where the trust continues to build asset base for the beneficiaries.
Yeah, and Catherine, you brought up a good point, because one of the salient features of the trust, we call it the private contract irrevocable trust, is that it is written in a way that the principles on which it is based don't change from generation to generation. So it's not going to be made obsolete, or it's not going to require to be changed just because the laws change outside in the world, because the principles of common law and the right of private contract go on century after century.
Right.
PL is saying, to open a new bank account for the trust, does the trustee and the beneficiary both have to be there in person?
Depends on the bank. More than likely, nowadays, more banks want the trustee to sign, although there are banks that don't, and we have a couple of online banks that can that operate, that actually will open account online. So it won't change anything. And again, if you show up at a bank, then you have to say, well, my trustee's in another town. Can we do a scan of his signature over here? And that's all it takes.
But I've never heard of a beneficiary being required to open an account. Have you?
Beneficiaries don't have any business opening account. If they're a beneficiary, the only account they'll open would be a personal account to receive the funds from the trust.
And furthermore, if they ask you who are the beneficiaries, tell them that's none of their business, because this is a discretionary trust.
Correct.
The bank does not have the responsibility to enforce the provisions of the trust. So Cindy's saying, I started a trust and paid the first $500 on it many years ago, possibly 2018. I would like to get it set up and complete payment. Who can I contact to do this? I'm hoping you have a record of previous efforts. Unfortunately, the computer I began on is not working. How best to proceed? And Cindy, I will send you a private response to that. Thank you for getting back in touch with us. Okay. PL saying, what is the typical minimum value of assets to feel that creating a trust is necessary?
Well, if you got $10,000, I'd put it in trust rather than my own pocket. But it depends on you, how much you value what you have in your pocket.
Mm-hmm.
If you can live with $10,000 loose change around your household, then fine, that's not a problem. And if you got $100,000 and you want to keep it in a really good account, then keep it in a trusted bank with in the name of a trust.
All right. And PL saying, how does the trust pay taxes when there is income?
It depends on whether you're filing a 1041. If you're in the system and filing a 1041, then you would just fill out the 1041 and indicate what was came in and what went out. If you're not in the system, then you wouldn't file anything.
That's it. And David says, thanks so much for your time. Oh, this is moving here. I get these words to stay still. Thank you so much for your time and knowledge. I have another appointment I have to attend. Thank you so much. And thank you, David. Okay. And Catherine says, all the more reason to live within that realm. I think she means the golden age or the realm of the free society. What Antonia is saying, what are the online banks we can open a trust in, please?
Well, you have more savvy, you have more of that. I'll let you be the contact person for that one, Tanzan.
Right, Antonio, there's a bank called Ally. It's in multiple states, and I have to get the URL to send you. But that's one that we've heard about. We haven't actually banked there yet, but it's supposedly welcoming trusts. But increasingly, you could just try. A lot of banks are increasingly learning how to authenticate new applicants remotely. It's a growing skill, I think. We've seen a trend in that. So lots and lots of banks may not even advertise it as such, but if you ask them, they might say, sure, we have a way to open it online or from a distance, you know.
Right, and what you have in your computer is you have the document totally, and usually the bank wants the first 11 pages, which is what I call the trust indenture, and then that signature there, and then trustee signatures, and then the certification of trust, and sometimes that's all they need. And that's all you have to leave them, and you don't take the minutes or make sure the minutes are kept in a different section of the trust document, and they're not left for the bank. Those are what's really private.
And Bo is asking, if a large family has several trusts running 2 or 3 businesses and holding multiple assets, that would require separate trusts. Can you speak to the challenges managing trustees and beneficiaries within the family and adverse trustees, so not to have any of the trusts look and act as the same trust within a multi-trust structure?
Like I said, you're going to have a non-related second party in there. You can't just trade trusts and be, settler and trustee for each other's trust. So you'd have to have a third party in there somewhere, but essentially each person could have its own trust and run the business through the trust. And then all you need is that an independent second trustee. And, so you have a family with 5 siblings in it. So each one of those 5 siblings plus the parents could each have their own business, and it would all be a thriving, vibrant business. It just needs to have a third party, non-related adverse trustee in there.
That appears to be the questions for the moment. Randall, any other news or knowledge you want to share?
No, just I realized I was back into one of my books the other day, and the way it was written is at some point along, you understand the trust law so well. Literally, as I read his document, I saw the innuendos of snide remarks. In other words, yeah, this is how the law is stated, and this is how, if you're really thinking about it and you understand the process, that you just swoop around this. And I was just a sense of humor within the law of trust is an odd commodity. I have to say that. So it was a fun 2 days. I think the chapter was about, it took me 2 days to get through. It's fairly intense, but I did enjoy it. So in other words, you can really enjoy the stuff if you have any kind of passion whatsoever. If you don't, then just leave it, but it can be fun to work with, and it's not that difficult.
Ariana saying, will this be available to view as replay? And the answer is yes. Ariana, we always post this on YouTube at brilliance-videos.com. So that this will be posted. Dan says, hi, my trust is 100% in cryptocurrency. My question is about the record of the trust. Can the record income and profit be in different cryptocurrency coins? Means there is not any mention of dollar value. Is it okay? Does it make sense?
Yes, a lot of people doing crypto. And you can run the trading through a number of different accounts. And I think you have to have a final destination where you put your money in and you get coins, and then you put the coins in and you get the money out. So you have to have that in place, but the trust can do all the crypto trading at once, any commodity.
And that's
Just
done
right
through,
there, the duties and the powers that the trustee contain are significant. One of them is trading any kind of commodity.
and that's done through the minutes and the Schedule A.
It's right in the first 11 pages of the document.
Right. But I mean, transferring asset title of ownership into the trust.
That's on Schedule A. Yes, it's all comes in the instructions.
And when you're titling ownership of an asset for the first time, you would create a minute with the resolution about it. Yes.
Correct. You just create a minute. I hereby assign so many cryptocurrency Bitcoins to this account and sign it in. And it's done. And then you put a copy of that record behind Schedule A in the schedule part, and then you put another copy in the minutes part. So dated, a date stamped and signed, and then you're carry on.
Yeah. Okay, everyone. Thank you. It's been a great meeting today. We'll go ahead and announce June 14th, put it on your calendar for the next one. And in between, go to brilliance-videos.com for playback. This will be posted in the next day or two. And of course, be in touch by email and phone with us if you have in-between questions. And Randall, I wish to thank you again and again and again. Dominique and Laurel and all of us on the team have been greatly benefited by your seasoned experience and wise guidance.
Yeah, we'll all add our wisdom to the show.
Those that look outside dream, those that look inside awaken. Carl Jung, that's a good one. And your life is a mirror. Everything inside of you shown outside of you. Life is your reflection.
Thank you, Johnson.
Well, aloha. And, you know, anyone, if you're interested in meeting with Randall after having your trust set up, he does welcome visitors to Kauai. So he told me many stories about meeting clients and how fun it was. So it can be a business trip and you don't need to write it off because there's nothing to write off, right?
That's right. Can just drink cold coconuts.
Rent the cola coconuts and enjoy the breezes, the cool ocean breezes.
Hey, aloha, everyone. Thank you.
Enjoy. Take care.